A federal judge ruled today that New Jersey's ban on AR-15 rifles is unconstitutional.
You are prioritizing the sale of AR-15s over the lives of our children.
Recent federal court ruling overturning New Jersey's ban on AR-15 style semi-automatic rifles.
The AR-15 should not be allowed in a civilized, safe society for children and for people in the general public.
Capacity magazines, the large capacity magazines, using his own language, I think that opens the door for an appeal.
A massive structural shift just completely fractured the legal landscape of American firearm regulations, and it happened over the course of a single afternoon inside a federal courthouse. In a stunning, highly unusual move, an entire lineup of federal appellate judges gathered together to issue a staggering 192-page judicial decision with a sharp 10-5 vote split. This powerful legal body did something that has never been achieved at this level of the American judiciary. They completely wiped out a major state's signature bans on semi-automatic firearms and standard capacity magazines, declaring them fundamentally unconstitutional. This historic ruling does not just impact local policies. It marks the very first time a federal appellate court anywhere in the nation has explicitly struck down an active statewide ban on AR-15 style rifles. The sheer gravity of this decision has sent shockwaves cascading across the entire country, completely upending years of settled policy and establishing a direct, unavoidable pipeline straight to the United States Supreme Court. To fully comprehend why this specific legal bomb exploded with such catastrophic force, you have to understand the sheer institutional weight of the court that delivered it. This monumental decision was handed down by the full en banc panel of the United States Court of Appeals for the Third Circuit. In standard legal proceedings, a federal appeals court typically reviews a case using a small, randomly selected three-judge panel. But when a legal battle is deemed exceptionally important, or when the underlying constitutional questions threaten to reshape the fabric of society, the court triggers an en banc review. That means every single active judge on the circuit is called to the bench to hear the case together and cast their votes. The Third Circuit is an immensely influential body, wielding vast jurisdiction over millions of citizens across the states of New Jersey, Delaware, and Pennsylvania. Because an en banc ruling represents the collective definitive stance of an entire federal circuit, it carries immense legal gravity. It completely binds the lower courts beneath it and makes it incredibly difficult for opposing legal teams to overturn without ascending to the highest court in the land. When the final tally of the votes was unsealed, it revealed a deeply fascinating, precise judicial alignment that immediately caught the attention of legal scholars across the country. The 10-5 majority that voted to strike down the restrictive laws wasn't just a narrow consensus, but a broad agreement that spanned across different legal philosophies and judicial generations within the court. This multi-judge alignment shattered the long-standing narrative that constitutional interpretations on these matters are completely unpredictable or strictly divided. When a significant majority of an entire federal circuit collectively agrees that a state legislature has exceeded its constitutional authority, it sends a powerful message. The structural boundaries limiting government regulation are fixed, distinct, and completely independent of contemporary local legislative desires.
The U.S. Appeals Court has ruled New Jersey's ban on assault rifles is unconstitutional.
You are prioritizing the sale of AR-15s over the lives of our children.
The Appeals Court has ruled that a state's assault weapons ban violated the U.S. Constitution's Second Amendment.
The AR-15 should not be allowed in a civilized, safe society for children and for people in the general public.
This explosive ruling was not achieved overnight. It is the hard-fought culmination of a relentless, exhausting 6-year legal war that originally kicked off back in 2018. The intense, multi-year litigation was spearheaded by two heavily influential civil rights organizations, the National Rifle Association, the NRA, and its dedicated state-level affiliate, the Association of New Jersey Rifle and Pistol Clubs, known as the ANJRPC. For nearly a decade, these groups poured immense financial resources, expert historical research, and elite legal talent into challenging the state's aggressive weapon restriction regime. Year after year, through disappointing setbacks at the lower court levels and endless rounds of procedural delays, the legal teams carefully built a massive, undeniable record of evidence. They were waiting for the precise constitutional questions to be forced into a definitive reckoning. That moment finally arrived, and the resulting 192-page opinion represents a total vindication for the legal arguments pushed forward by the millions of gun owners who backed this grueling legal case for nearly a decade. At the absolute center of this historic judicial destruction was a strict, unyielding application of the text and history standard established by the Supreme Court's monumental Bruen decision. Under this modern constitutional framework, courts are strictly prohibited from using the old, highly criticized practice of means-end scrutiny. That is a judicial balancing act where judges would historically allow states to enforce restrictions if the government could simply argue that public safety benefits outweighed an individual's personal liberties. The Bruen framework completely erased that loophole, establishing a rigid, two-part formula that changes everything. First, judges must determine if the plain text of the Second Amendment covers the specific firearm or component an ordinary citizen wants to possess. If it does, the firearm is automatically presumed to be protected by the Constitution. The entire burden of proof then shifts squarely onto the shoulders of the state government. The state must point to a robust, deeply ingrained historical tradition of firearm regulation from the founding era of the United States to justify their modern restriction. If the state cannot find a clear historical twin from the late 18th century, the modern law must be immediately struck down. When the state's elite legal teams attempted to defend their aggressive restrictions before the full appellate bench, they hit a brick wall of historical reality. The state scrambled to present various colonial-era safety regulations and mid-19th century weapon restrictions, desperately trying to construct a historical narrative that supported an outright ban on modern firearms. However, the appellate majority meticulously picked these historical arguments apart. They noted that the state failed to provide a single compelling historical analog from the founding era that ever permitted the government to flatly prohibit peaceful citizens from owning commonly possessed legal firearms. The court made it abundantly clear that the government cannot simply invent a historical tradition or patch together irrelevant, localized historical statutes to justify a sweeping statewide prohibition on modern consumer technology. Because the founding generation never tolerated the idea of the government banning the primary defensive tools of the everyday populace. The state's modern regulatory regime was found to be completely alien to the American constitutional tradition. This unwavering historical analysis ultimately spelled the complete and total death of the state's highly controversial firearm platform ban. For years, regional laws had successfully restricted a vast array of popular modern firearms by attaching specific statutory definitions that targeted the iconic AR-15 platform and a multitude of similar semi-automatic rifles. The state argued that these rifles were uniquely dangerous, specialized weapons that fell entirely outside the protections of the Second Amendment. However, the appellate court completely rejected this legislative classification campaign. The judges looked past the rhetorical framing and focused heavily on objective consumer data. They emphasized that semi-automatic rifles are standard, everyday tools overwhelmingly chosen by millions of law-abiding American citizens for entirely legitimate lawful purposes, like home defense, competitive shooting sports, and recreational hunting. Because these firearms are in massive, widespread common use across the nation, they are fundamentally protected by the plain text of the Constitution. The state's sweeping attempt to criminalize their possession was a flagrant violation of the Second Amendment. But the appellate court did not stop at liberating the rifle platform itself. They simultaneously executed a complete demolition of the state's strict ban on ammunition magazines that hold more than 10 rounds. For years, the state had enforced a strict cap, labeling any magazine capable of holding 11 or more bullets as a restricted component and transforming ordinary citizens who possess them into instant violators of the law. The state's primary legal defense for this restriction was an aggressive argument that ammunition magazines aren't even arms under the text of the Constitution. They claimed magazines are merely optional, unregulated accessories that the government can restrict at will without ever triggering strict constitutional protections. The en banc majority completely crushed this legal interpretation, applying basic common sense to the mechanics of modern firearms. The court ruled that because an ammunition magazine is a completely indispensable, vital component required for a semi-automatic firearm to operate as intended, the magazine itself is fundamentally protected as an arm under the Second Amendment. A semi-automatic rifle without a functional magazine is nothing more than a non-firing piece of machinery. Therefore, the container that feeds the firearm is constitutionally inseparable from the firearm itself. Once the court firmly established that ammunition magazines are independently protected by the Constitution, the state's entire regulatory defense instantly collapsed. The appellate judges looked directly at the modern market data and noted that standard capacity magazines capable of holding 15, 20, or 30 rounds are the factory standard components shipped with hundreds of millions of handguns and rifles owned by peaceful citizens across the United States. Because these standard components are overwhelmingly possessed by the millions for entirely lawful activities, they effortlessly pass the common use test. The court flatly rejected the arbitrary idea that a magazine is perfectly constitutional when it holds 10 rounds, but suddenly becomes an unprotected public hazard the exact moment an extra round is slipped inside. By forcing the state to adhere to the true text of the Constitution, the court effectively dismantled the legal framework that allowed states to artificially limit the mechanical capabilities of law-abiding citizens. The immediate systemic fallout from this massive legal defeat was swift and highly consequential for the regulatory framework of the region. Within minutes of the decision being unsealed, administrative offices and legal teams across the state began reviewing the massive text of the opinion to assess its immediate operational impact. The big question now is, what happens next? Will local firearms dealers immediately begin stocking semi-automatic rifles and standard capacity magazines on their shelves without restriction? The reality is a bit more complicated. As a massive legal process is about to unfold, the state will almost certainly file an emergency appeal, taking the case straight to the United States Supreme Court. Legal experts predict that the High Court will likely hold a quick conference on the matter and then temporarily place the case on hold. They will keep it in limbo until they issue a final, definitive ruling on the highly anticipated Vera Montez case out of Cook County, Illinois. However, this temporary pause does not diminish the sheer historical weight of what just happened. Up until this point, if the Supreme Court wanted to strike down an assault weapon or magazine ban, they had very little support from the lower appellate courts. Every single federal circuit that had ruled on the issue in recent years had upheld the restrictions. That unbroken wall of judicial consensus has officially been shattered. With this new opinion, the Supreme Court now has a meticulously reasoned, rock-solid appellate framework to point to, completely validating the originalist interpretation of the Second Amendment. This caps off a remarkable stretch where constitutional challenges have secured unprecedented victories across the federal court system, fundamentally shifting the balance of legal interpretation in America. That's it for today, folks. See you in the next video.